The marble walls of the Supreme Court chamber seemed to hum with tension as Congresswoman Jasmine Crockett faced the 9 justices. Her navy blue suit stood out sharply against the rich mahogany podium. C-SPAN cameras zoomed in just as Justice Clarence Thomas leaned forward, his expression firm and unyielding. What followed sent ripples through the entire legal community. "Congresswoman," Thomas began, his deep voice cutting through the silence, "I've read your brief several times, and I must say, your grasp of constitutional law appears elementary. Perhaps you should revisit the fundamentals of legal interpretation before appearing before this court." The room fell silent. Reporters froze mid-typing. The other 8 justices shifted uneasily in their high-backed chairs, but Crockett didn't waver. Her eyes narrowed slightly as she tightened her grip on her legal pad and reached for a folder her assistant had prepared. "Justice Thomas," she replied, her voice calm but firm, "I appreciate your concern for my legal education, but over the next 5 minutes, I'll demonstrate exactly why your assessment is not only incorrect, but dangerously misleading to the American public. No, one could have predicted what would happen next." The folder she opened contained research that would not only affirm her legal expertise but also turn Thomas's own judicial record against him, leaving the senior justice momentarily speechless for perhaps the first time in his 3-decade career. Before we unpack this remarkable exchange, take a moment to like this video and subscribe to our channel for more sharp political analysis you won't find anywhere else. Tap the notification bell so you never miss a major moment in American politics. Justice Clarence Thomas sat in his familiar center-right seat on the bench, his presence commanding as ever after more than 30 years on the nation's highest court. At 75, Thomas had grown increasingly outspoken and combative. Gone was the justice who once went years without asking a single question during oral arguments. In his place stood a resolute conservative, a voice unafraid to challenge anyone he believed lacked proper respect for his originalist view of the Constitution. The Constitution means what it meant when it was written, he had famously written in a recent opinion, not what some progressive lawyer wishes it meant today. For Thomas, this wasn't merely another case, it was a test of the very principles that had defined his judicial philosophy. The voting rights case before the court carried enormous implications for upcoming elections, and Thomas appeared ready for a fight. Facing him was Congresswoman Jasmine Crockett, a 42-year-old former civil rights attorney from Dallas. In just her 2nd term in Congress, she had already made her mark as a rising figure in Democratic politics. Her background included defending protesters, battling voter suppression, and winning complex civil rights cases across Texas. Before entering Congress, she had earned a reputation as a persuasive courtroom advocate, skilled at breaking down intricate legal issues for juries. Crockett was invited to present arguments in this case. Due to her deep knowledge of voting rights in southern states, she knew she wasn't just representing her constituents. She was standing for millions of voters whose access to the ballot box was on the line. "This isn't academic for me," she had told her team while preparing. "I've seen voters turned away, polling sites shut down, and entire communities silenced." Justice Thomas may see this through the lens of constitutional theory, but I've witnessed its human cost. The stakes could not have been higher. The case, Richardson vs. Election Commission of Georgia, centered on new voter ID laws that could disenfranchise hundreds of thousands of citizens, disproportionately impacting minority communities. The conservative justices, led by Thomas, appeared inclined to uphold the legislation. Some viewed the restrictions as necessary security measures, while liberal justices regarded them as barely concealed efforts at voter suppression. The atmosphere in the courtroom was tense, even before the exchange began. Legal analysts in the gallery whispered that the court seemed poised for a 5-4 split, with Justice Thomas expected to write what could become a landmark majority opinion, shaping American voting rights for decades. Thomas's dismissive comment was more than a personal slight. It was a calculated move to discredit not only Crockett's arguments but her authority as a legal expert altogether. By questioning her grasp of constitutional law, he sought to weaken the foundation of everything she intended to present. What Thomas didn't realize was that Crockett had anticipated this approach. Her team had studied his increasingly confrontational style and had prepared for it meticulously. The folder in her hand contained material that would turn this ordinary Supreme Court argument into a moment studied in law schools for generations. The chamber was silent as Crockett gathered her thoughts. Justice Elena Kagan glanced at Thomas, eyebrows slightly raised. Justice Ketanji Brown Jackson straightened her posture, now visibly attentive. Everyone sensed that something unusual was about to happen. Justice Thomas, Crockett began, her voice steady and firm. I'd like to address your concern about my understanding of constitutional law by directly examining the principles at issue. Thomas leaned back, a faint, dismissive smile crossing his face. Please proceed, Congresswoman. Educate us. The condescension in his tone was unmistakable. Several journalists exchanged knowing glances. Thomas's increasingly combative manner had been noted before, but rarely had he been so openly dismissive of a lawyer arguing before the court. The 14th Amendment's Equal Protection Clause and the 15th Amendment's guarantee of voting rights, regardless of race, form the constitutional basis of my argument, Crockett explained clearly. The Georgia statute creates barriers that disproportionately impact specific communities, as detailed on page 34 of my brief. Thomas interrupted sharply. Congresswoman, I'm well aware of what those amendments say. What you appear to misunderstand is that they guarantee equal treatment, not convenience. The Georgia law applies to every voter in the same way. Several conservative justices nodded. Justice Samuel Alito leaned toward his microphone. To expand on Justice Thomas's point, where in the Constitution do you find a right to vote without presenting identification? The questioning was turning into a coordinated challenge, but Crockett stood firm. Respectfully, Justice Alito, the Constitution's protections extend to ensuring that laws appearing neutral on their face do not produce discriminatory effects. The data clearly shows data can be manipulated, Thomas interjected. What cannot be manipulated is the text of the Constitution, which says nothing about how states verify voters. Perhaps this is the elementary distinction I mentioned earlier. A few quiet gasps rippled through the gallery. Thomas had doubled down, effectively accusing Crockett of misrepresenting evidence. Chief Justice John Roberts shifted uneasily. Concerned that the exchange was becoming personal, Crockett inhaled deeply as her assistant discreetly handed her another document. Statistical analyses from 3 independent institutions confirming the Georgia law's disparate impact. Yet she knew data alone would not shift Thomas's dismissive tone. Justice Sonia Sotomayor tried to redirect the discussion. Let's focus on the evidence in the brief regarding access issues in rural Georgia counties. With respect, Thomas interrupted again, his gaze still fixed on Crockett. We need to clarify a fundamental misunderstanding of constitutional principles before addressing county-level data. The Congresswoman appears to be advocating for results-driven jurisprudence rather than textual fidelity. The tension escalated. What had begun as a high-stakes voting rights argument had become a test of Crockett's credibility. Some observers would later note that Thomas seemed unusually intent on discrediting her personally, rather than merely debating her reasoning. Crockett glanced at the clock. Her time was running out. Thomas's interruptions had consumed precious minutes. She needed to shift the momentum. Justice Thomas, she said calmly, you've questioned my understanding of constitutional interpretation several times today. I believe it's appropriate to address that directly by examining how these principles have been applied by this very court. She opened her folder and withdrew a document her research team had compiled through long nights of preparation. It contained findings that would alter the tone of the entire session. In preparation for today's argument, my team analyzed every voting rights opinion you have authored or joined since your confirmation in 1991. Our goal was not to assess political views, but to evaluate consistency in constitutional interpretation. Thomas's expression shifted slightly. The other justices leaned forward, intrigued by where she was going. What we discovered, Crockett continued, her confidence growing, was a consistent pattern I'd like to discuss in relation to today's case. Specifically, your concurring opinion in Shelby County versus Holder, where you asserted that Section 5 of the Voting Rights Act was unconstitutional from its inception. not merely in its application. Thomas's jaw tightened. Crockett had just confronted his most controversial position on voting rights. "I have the data here," she said. Crockett held up several pages of neatly arranged charts. "What these charts reveal about the consistency of constitutional interpretation," she began, "might surprise everyone in this chamber." The room fell silent. Even the court reporters seemed to pause. Justice Thomas's earlier dismissive attitude was gone, replaced by focused attention on the papers in Crockett's hand. "Congresswoman?" Chief Justice Roberts interrupted, glancing at the clock. "You have 10 minutes remaining." Crockett nodded respectfully. "Thank you, Mr. Chief Justice. That's more than enough time to show why Justice Thomas's evaluation of my understanding is not only incorrect, but highlights a deeper issue this court should recognize." Thomas leaned forward, hands clasped tightly. The exchange had moved beyond legal disagreement. Crockett was about to challenge not just his critique, but his judicial consistency spanning 3 decades. The chamber sensed that something significant was about to unfold. Jasmine Crockett straightened her shoulders, her composure unwavering. The courtroom was utterly still. No rustling papers, no murmured discussions among clerks. Even the press, usually restless, remained motionless. "Justice Thomas," Crockett began, her tone firm and steady, "you suggested that my understanding of constitutional law is elementary. I'd like to respond by reviewing your own application of constitutional principles in voting rights cases." She placed a document on the podium and rotated it so the justices could see the timeline it displayed. "This chart tracks your opinions on voting rights from 1991 to the present. What emerges," she continued, "is a pattern that's difficult to reconcile with the originalist approach you claim to uphold." Thomas's face remained expressionless, but his fingers tapped lightly on the bench, a rare sign of unease. "In Crawford versus Marion County, 2008, Crockett continued, you joined the majority in upholding Indiana's voter ID law, citing the state's interest in election integrity, despite minimal proof of actual fraud. Yet in your dissent in Arizona versus Intertribal Council, 2013, you argued that state sovereignty should override federal election oversight, an argument that effectively reverses your earlier stance on federal versus state power." Crockett turned another page. "But the most revealing inconsistency," she said, her voice gaining strength, "appears in Shelby County versus Holder. You argued that the Voting Rights Act's pre-clearance requirement was unconstitutional because current data didn't justify treating states differently for past discrimination." She paused, locking eyes with Thomas. "Yet in your dissent just last term in Allen versus Milligan, you dismissed contemporary evidence of ongoing discrimination, claiming the act couldn't constitutionally address racial gerrymandering at all. That position suggests that neither historical nor current data matter, contradicting your own reasoning in Shelby County." A quiet stir spread across the courtroom. Justice Kagan leaned forward, clearly intrigued. Justice Kavanaugh shot a glance at Thomas. "These contradictions," Crockett continued, her tone steady but resolute, "reveal something important. The inconsistency isn't found in the Constitution itself, which has remained the same. It wasn't inconsistency in principle," Crockett argued. "It was the selective application of those principles to fit a desired outcome." Thomas's expression darkened. He leaned toward his microphone, but Chief Justice Roberts subtly raised a hand, a quiet reminder not to interrupt during a timed argument. "I didn't come here today just to criticize," Crockett continued firmly. "I came to defend the right to vote." She lifted a blue folder. "Inside are sworn affidavits from 173 Georgia voters who were unlawfully denied ballots despite being eligible citizens." She paused, then added, "Among them is Mrs. Dorothy Wilson, an 86-year-old woman who has voted in every election since 1956, yet she was turned away because her married name on her ID didn't match her maiden name on outdated voter rolls." Crockett held up a photo of an elderly black woman displaying her voter registration card and driver's license. Mrs. Wilson was born under Jim Crow laws. Justice Thomas. She marched with Dr. King, and in 2024, she was told by a poll worker she couldn't vote due to a clerical mistake. Thomas's face softened slightly, the first trace of emotion breaking through his judicial composure. "The Constitution's meaning does not change. Justice Thomas, Crockett continued, her tone steady, and on that point we agree. The 15th Amendment clearly states that the right to vote shall not be denied on account of race. When a law leads to the disenfranchisement of Mrs. Wilson and thousands like her, while voters in predominantly white districts encounter no such obstacles, that is exactly what the framers sought to forbid. She turned to address the full court. My understanding of constitutional law isn't theoretical. It's grounded in its impact on real Americans. The Constitution wasn't written as an abstract exercise. It was written to protect people like Mrs. Wilson. She placed the affidavit on the podium deliberately. With respect, Justice Thomas, what's truly simplistic is pretending that so-called neutral laws, which have clear, discriminatory effects, somehow uphold the Constitution's text and intent. The courtroom fell silent. Several justices took notes quickly. Justice Jackson's expression held the faintest trace of a smile. Justice Alito looked uneasy. Thomas leaned forward, his earlier dismissiveness replaced by focused attention. "Congresswoman," he began, his tone notably more measured, "you suggest inconsistency on my part, but couldn't the same argument apply to changes in your own legal views over time?" It was a sincere question, not a dismissal, the kind of exchange reserved for respected equals. Crockett nodded. "A fair question, Justice Thomas. My views have evolved as I've seen how these laws function in practice. The difference is, I don't claim unwavering originalism as the foundation of my philosophy. I openly acknowledge that witnessing Mrs. Wilson turned away from her polling place shapes my understanding of what the 15th Amendment protects." She gestured toward the affidavits. "These aren't abstract theories. These are American citizens being denied their most basic right. If defending their access to the ballot makes my approach elementary, then perhaps this court could use a bit more elementary thinking." Thomas leaned back, his face unreadable, but the earlier trace of mockery was gone. For perhaps the first time in his long judicial career, he seemed momentarily without words. Chief Justice Roberts cleared his throat. "Your time has expired, Congresswoman Crockett. Thank you." As Crockett gathered her materials, something rare occurred. Justice Ketanji Brown Jackson gave a subtle nod in her direction, a quiet but unmistakable sign of respect. Even more unexpectedly, Justice Brett Kavanaugh leaned toward Justice Barrett, whispering something that left both appearing thoughtful rather than dismissive. The attorney for the state of Georgia stepped up for rebuttal, but the atmosphere in the chamber had shifted entirely. The confident energy that had radiated from the conservative justices earlier had been replaced by a cautious, reflective silence. What began as Thomas's attempt to publicly undermine Crockett's legal authority evolved into something far different. In a striking moment, a congresswoman not only held her ground, but directly challenged one of America's most influential justices, on his own terms, using his own rulings and language against him. As Crockett returned to her seat, reporters quietly left the courtroom to file their stories. Whatever the court's ultimate decision might be, today's exchange had already become the headline. Within minutes of the Supreme Court session concluding, social media lit up. A CNN legal correspondent tweeted, "Unprecedented. Reporter Crockett turns tables on Justice Thomas after he questioned her legal expertise. Most direct challenge to a sitting justice I've witnessed in 2 decades, covering SCOTUS." By the time Crockett exited the Supreme Court, her phone buzzed non-stop with notifications. The hashtags Joe Crockett vs. Thomas and Elementary Mr. Thomas were trending nationwide. Major news networks dropped their scheduled programming to cover what commentators were calling a historic confrontation at the highest court in the country. On the marble steps outside, reporters crowded around her. "Congresswoman, were you expecting Justice Thomas to question your legal background?" one shouted. Crockett paused, then replied carefully, "I came prepared to defend voting rights, not my credentials. But yes, my team anticipated tough questions, and we prepared for them." Another reporter asked, "Do you think your exchange with Justice Thomas could influence the court's decision?" "That's not for me to predict," Crockett answered calmly. The justices based their rulings on constitutional interpretation, not on courtroom exchanges. "I simply presented the facts as I understand them." Yet behind her composed tone, Crockett's team recognized that something extraordinary had taken place. Later that afternoon, as they regrouped in her congressional office, her chief legal advisor shared what he'd heard. "The clerk I spoke to said Thomas didn't say a word during the conference," he reported. "That's unheard of. He always opens with his stance on voting cases." By evening, clips from the hearing had gone viral. The moment Crockett unveiled the timeline of Thomas's conflicting opinions had been viewed more than 7 million times across social media. Law professors were already assigning the transcript to their students. Constitutional scholars from across the political spectrum weighed in. Many, regardless of ideology, commended Crockett's precision and composure. Harvard law professor Lawrence Tribe tweeted, "Agree or disagree with her position, Rep. Crockett demonstrated exceptional advocacy. Using a justice's own opinions to question consistency is argumentation of the highest caliber." A panel of conservative legal scholars convened, some defending Justice Thomas, while others acknowledged the effectiveness of Crockett's approach. "She didn't attack him personally," noted one conservative commentator. "She challenged the consistency of his judicial philosophy using his own rulings. That's fair game, and honestly it was brilliantly done." On MSNBC, legal analyst Neil Katyal, who has argued numerous cases before the Supreme Court, expressed genuine astonishment. "What we saw today was remarkable. Most advocates spend their careers avoiding direct challenges to justices. But Crockett did more than confront justice. Thomas's dismissive tone, she systematically exposed contradictions in his judicial record that he couldn't easily deflect." The White House refrained from direct comment, with the press secretary simply stating that the president believes robust legal debate strengthens democracy. Behind the scenes, however, insiders reported that senior administration officials privately reached out to Crockett's office to express their support. By the next morning, the story dominated national headlines. The New York Times led with, "In rare Supreme Court confrontation, Congresswoman challenges Justice Thomas's consistency on voting rights." The Wall Street Journal ran with, "Supreme drama. Crockett's methodical response raises questions about judicial consistency." Law schools across the country reported a surge in applications citing an interest in voting rights law. Civil rights organizations also saw a spike in donations, many donors referencing Crockett's defense of Mrs. Wilson and others like her. For Crockett, the aftermath brought both opportunity and scrutiny. Interview requests poured in from major networks. Law conferences invited her as a keynote speaker. Rumors circulated that she was being considered for leadership roles within the House Democrats' judiciary strategy teams, but increased visibility brought challenges. Conservative media began probing her legal career for inconsistencies or past missteps. Security concerns escalated after several online threats, prompting Capitol Police to heighten patrols near her office. 3 weeks later, as speculation about the court's decision reached a peak, Crockett addressed students at Howard University School of Law. "What happened in that courtroom wasn't about me or Justice Thomas," she told the packed audience. "It was about whether our legal system can look beyond theory to see how laws affect real people. It's about whether the Constitution protects every American or only those who fit a certain mold." During the Q&A, a student asked if she thought her exchange might change Justice Thomas's perspective on voting rights. Crockett smiled. "I don't expect to alter his judicial philosophy," she replied, "but I do hope it pushes the court to confront the gap between constitutional theory and lived experience. Mrs. Wilson doesn't care about originalism or living constitutionalism, she just wants to vote." Meanwhile, inside the Supreme Court, the justices were deep in deliberation. Anonymous sources told trusted court reporters that the initial vote had been 5-4 along ideological lines, with Thomas set to write the majority opinion upholding Georgia's strict ID laws. But something unexpected occurred during drafting. Thomas's first version reportedly ignored the statistical evidence Crockett had introduced, focusing instead on abstract constitutional reasoning. Justice Barrett allegedly sent a private memo questioning whether the opinion adequately addressed the law's disparate impact on minority voters. Justice Kavanaugh, too, raised concerns about the optics of dismissing sworn affidavits from affected citizens like Mrs. Wilson. 2 months later, when the court released its decision, legal observers were stunned. In a surprising 6-3 ruling, the court struck down key parts of Georgia's voter ID law while upholding others, a balanced opinion acknowledging both security concerns and access issues. Most strikingly, the majority opinion was authored by Chief Justice Roberts and joined by Thomas, the court's 3 liberal justices, plus Barrett and Kavanaugh. The opinion cited compelling evidence showing that certain provisions created unnecessary barriers that disproportionately affected specific communities. In a rare concurring opinion, Thomas wrote, "While I continue to believe the Constitution's text provides ultimate guidance, I recognize that faithful application requires careful attention to real-world effects on citizens, such as those who testified in this case. The 15th Amendment's ban on racial discrimination in voting extends beyond explicit mentions of race to include laws that achieve the same outcome through subtle means. The evidence here shows certain provisions of Georgia's law fall into that category." Legal scholars quickly noted the shift in Thomas's position, one many credited to his exchange with Crockett. 6 months later, Crockett launched a new Voting Rights Institute dedicated to collecting and analyzing data on voting access nationwide. Donations poured in from across the country. The Institute's first hire was a full-time staffer tasked with helping voters like Mrs. Wilson navigate ID requirements and bureaucratic hurdles. At the launch event, Crockett reflected on what the moment truly meant. "Some people called it a victory when Justice Thomas joined the majority opinion," she said. "But the real victory belongs to Mrs. Wilson and to every American who can now vote without unnecessary obstacles. This isn't a partisan win, it's an American win." As the midterms approached, Georgia saw record voter registration numbers, with many citing the Crockett case as their inspiration. In a small church basement in rural Georgia, 87-year-old Dorothy Wilson spoke to first-time voters, proudly holding her new voter ID card. "I've been voting since Eisenhower was president," she said, her voice firm. "And thanks to what happened in that courtroom, I'll keep voting as long as I'm able." What began as a tense courtroom exchange had evolved into something far greater, a reminder that behind every legal theory are real people whose rights hang in the balance. For Crockett, this wasn't about winning an argument with a Supreme Court justice. It was about making sure the Constitution's promises are kept for all Americans, no matter where they live or what ID they carry. As this story continues to shape American legal and political history, don't forget to like and subscribe for more in-depth analysis of the moments defining our democracy. Hit the notification bell to stay updated on major developments in voting rights cases, and share your thoughts below on this historic exchange between Justice Thomas and Congresswoman Crockett. Your voice matters in the ongoing conversation about the future of American democracy.